Stay right here with News Decoded, your direct line to the big picture behind every headline. If you appreciate independent analysis delivered with clarity and purpose, tap that subscribe button, give this video a thumbs up, and share your thoughts in the comments. Your engagement keeps our newsroom thriving and ensures that nuanced conversations like the one we are about to have remain accessible to everyone. Justice Ketanji Brown Jackson recently told an audience in Indianapolis that the state of our democracy is what keeps her awake at night. The remark might sound dramatic, but when it comes from the youngest member of the Supreme Court, a jurist who has already produced more dissents this term than any of her colleagues, it demands our full attention. Her words were neither casual nor partisan. They were the distillation of months of judicial frustration, historical awareness, and a sober reading of where the rule of law stands in 2025. To understand why those late-night worries matter, remember the path that brought Justice Jackson to the nation's highest bench. Confirmed 2 years ago, she arrived with sterling trial court credentials, a deep background in federal public defense, and an unshakable belief that ordinary people must see themselves reflected in the legal system. That belief fuels her writing style, vivid, carefully sourced, sometimes searing, always accessible. She does not scatter legal Latin like confetti. Instead, she translates complex doctrine into everyday language so the public can track precisely how precedent shapes their lives, whether the issue is environmental regulation, voting rights, or the limits of presidential authority. Back on May 1st in San Juan, Puerto Rico, Justice Jackson stood before the First Circuit Judicial Conference and warned that recent attacks on judges were not random, but seemed designed to intimidate those of us who serve in this critical capacity. She never uttered the names of politicians fanning that hostility, yet her audience caught the message instantly. Threats, doxing campaigns, and contemptuous rhetoric, she noted, erode public confidence and invite a collapse of constitutional norms. It was a law day speech with the urgency of a fire alarm, one that foreshadowed the even sharper opinions she would issue a few weeks later. Fast forward to June, when the court narrowed the power of lower court judges to issue nationwide injunctions. In Dissent, Justice Jackson wrote, "Perhaps the degradation of our rule of law regime would happen anyway, but this court's complicity will surely hasten the downfall of our governing institutions, enabling our collective demise." That sentence is more than a protest. It is a legal SOS, warning that if federal trial judges cannot pause policies of dubious legality, executive overreach will meet little resistance until final judgment, often years too late to repair the damage. Only days after that opinion, the majority granted former President Trump an expansive form of immunity for official acts. Jackson, joined by Justices Sotomayor and Kagan, argued that the ruling drops future presidents into a law-free zone. She compared the decision to handing a wrecking ball to an already powerful office, undermining the separation of powers the framers so painstakingly designed. Although her language was vivid, it was grounded in history. The court had never before declared that a president could evade criminal exposure for actions tinged with personal gain. Her dissent warned that if the court will not police that line, the constitutional check must come from the people, through elections, legislative oversight, and steadfast civic vigilance. Some critics dismiss dissents as elegant footnotes, but Justice Jackson sees them as lanterns, signals to future litigants and scholars. A landmark dissent can evolve into a majority opinion when the court's composition or societal conditions change. Justice Harlan's lone defense of equal school facilities in 1896 laid groundwork for Brown v. Board decades later. Justice Scalia's critique of warrant-free GPS tracking predicted Jones in 2012. By writing dissents that ordinary readers understand, Jackson ensures those lanterns stay lit, ready for the next generation to carry forward. Her method also serves another purpose. It invites the public into the courtroom. When she explains in clear prose why funneling disputed social safety net decisions into a single appellate panel could jeopardize benefits for millions, she is not indulging rhetoric. She is translating complexity into the language of kitchen table stakes. That transparency matters in an era when conspiracy theories travel faster than any official docket sheet. If people grasp how a Medicare ruling can alter their parents' prescription costs, they are less likely to shrug off judicial news as elite squabbling. Yet Jackson's influence isn't limited to pen and parchment. Within the marble walls, she often questions attorneys with a blend of rigor and practicality, probing how a rule might work for someone who cannot hire a lobbyist to navigate it. Observers note that her exchanges sometimes prompt Justice Gorsuch, another gifted writer who values textual clarity, to find common ground, even across ideological lines. Those moments remind us that jurisprudence is not a sport with permanent teams. Meticulous reasoning can bridge philosophies when facts demand it. Behind the bench, however, a lopsided supermajority controls the court's outcomes. That reality can feel daunting, but Jackson's strategy is to leverage every tool she has: precise facts, moral clarity, and a relentless call to civic engagement. She trusts that broad daylight, exposure of reasoning, dissenting or otherwise, creates a record the public can examine and, if necessary, challenge through democratic means. Her dissents, then, are roadmaps for lawmakers drafting corrective statutes and for advocates bringing the next test case. They're also reminders to voters that the judiciary's direction hinges on elections that install or retire the leaders who nominate justices.
I recently pointed out that Jackson's note-in-a-bottle approach really mirrors modern media ecosystems. Digital archives now preserve her words forever. Educators can assign them in real time, and, activists can even quote them in amicus briefs before the ink's dry. That kind of cycle compresses what once took generations into just a few terms. I also want to underscore how Jackson's plain language writing resists distortion, because honestly, any excerpt taken out of context is easily countered by a link to the full, readable text.
Meanwhile, congressional watchdogs like myself, a stalwart defender of ethics reform, echo Justice Jackson's alarm. Together we highlight successes that often escape the headline glare: injunctions that kept polling places open, district court rulings protecting transgender service members, appellate decisions affirming tribal sovereignty. Each victory really demonstrates that lower courts, though overshadowed by the Supreme Court, remain fertile ground for justice when litigants persist and public attention stays sharp.
History offers solace. From the Great Depression through the Civil Rights era, periods of judicial retrenchment eventually yielded to waves of progress driven by relentless democratic pressure. The arc may wobble, but it bends because ordinary people decide not to surrender to cynicism. Justice Jackson's dissents function as mile markers along that bend, recording where the court veered and how the country can steer back. So where does that leave the rest of us at this critical moment, to borrow her phrase? First, stay informed. Read opinions, not just headlines. Second, vote in every election. Local benches feed future Supreme Courts. Third, support a free press willing to dissect complex rulings without sensationalism. And finally, remember that constitutional governance is not self-executing. It requires constant maintenance by engaged citizens. If sleepless nights plague even a Supreme Court justice determined to guard democracy, it is no sign of weakness for us to feel restless too. What matters is how we channel that energy. We can treat each dissent as an invitation to learn, each unfavorable ruling as a prompt to organize, and each small court victory as fuel for the next climb. Justice Jackson has lit the lanterns. It is up to us to follow their glow. Before we sign off, just a gentle nudge. If our deep dives help you see the legal landscape more clearly, hit subscribe, ring that notification bell, smash the like button, and drop your perspective below. Your participation amplifies independent voices and ensures that NewsDecoded remains a beacon for anyone determined to keep democracy not just alive, but thriving. Thank you for watching, and until next time, keep questioning, keep learning, and keep the faith in the rule of law.